No, Amanda's not ready.
To left. Other way. Down a little bit. A little more the other way. Perfect.
Good afternoon, everyone. My name is Kelly Simon. I'm the legal director for the ACLU of Oregon, and I use she, her pronouns. The ACLU has been litigating protest cases for a century, and we will remain steadfast in defending this most crucial right against any incursions. As we did during Trump's first presidency, we will continue to bring lawsuits on behalf of protesters and journalists to defend the First Amendment and the basic freedoms that form the foundation of our democracy. The freedom to protest and a free press go hand in hand to protect our democracy. Protest is a vital tool for we, the people, to hold our government accountable to us and to work together toward a more connected and just future for everyone. The public exchanges that protests promote also depend on a free press, a press free to tell the truth about the publicly expressed messages and the government's response to them. A free press keeps the public informed and keeps the record clear about our government's actions. No one should be afraid to express dissent, to advocate for change, or to support causes they believe in. No one should be afraid to document and report on the truth. We will ensure that the Trump administration's efforts to silence dissenters and the journalists who report on that dissent will not go unanswered. These rights are not unconditional. Because the government has an interest in maintaining peace and public order, it may restrict some protest activities. But the government cannot control the marketplace of ideas. Retaliating against peaceful protesters and journalists threatens community safety and has a chilling effect on expression. Using tear gas and munitions to terrorize and retaliate against people from all walks of life for protesting not only silences the people protesting, but it also has far-reaching impacts on the First Amendment freedoms of many more. Watching our government unleash violence in our neighborhoods and cities impacts all of us. The pain and fear are the point. It makes us all afraid to speak up. No child, no person should be afraid of being subjected to poison gas or projectiles just for having an opinion and expressing it. Portlanders have protested against DHS's cruel immigration policies by exercising the First Amendment rights, singing and dancing, and coming together in community, and we are proud to defend them. And before I pass the mic, I would like to read the following from Lori Ekman, one of our clients in this case. Lori says, Richard and I have become sort of the 84-year-old couple, and we're honored by that. And truth be told, in some ways, we were at ICE because we are old. We are old enough to think that peacefully protesting is a time-honored way to stand up and say publicly what we think must be changed. We were kids when Hitler was in power, and when Japanese people were forced into internment camps, and during the era of the McCarthy hearings. And I myself protested during the Vietnam War that Richard proudly served in. And we have lived through the power of protest during the civil rights movement. As members of the general public, there are ways we can make our opinions count. We can vote, we can write our congresspersons, and go to town halls. But protesting is something we can do every day to stand up publicly, in person, and in connection with our neighbors and community members. We are honored that the ACLU and their legal partners are standing with us to protect this precious right so that we can pass it on to our grandchildren.
My name is Kim Hutchison, and I use she, her pronouns. The right to protest is a constitutional right guaranteed by the First Amendment. It includes everything from speaking and holding signs to symbolic speech like wearing an armband or a chicken suit. And it also protects peaceful marches and assemblies in certain public spaces. The First Amendment also protects free speech, even in Portland, Oregon, a city I hold close to my heart that has a community with its own creative and unique way to nonviolently protest and a rich history of free speech demonstrations. We are proud to challenge the Trump administration for its blatant violence against nonviolent protests through our office here in Portland and with the support of our offices all over the nation. The right to nonviolent protest is critical to a functioning democracy and at the core of the First Amendment. Protecting free speech means protecting a free press, the democratic process, our right to protest, and a diversity of thought. We cannot accept and normalize harassment and retaliation against nonviolent protesters. No one should be at risk of violence for peacefully protesting and making their voice heard.
My name is Jack Dickinson. I use he, him pronouns. I am here to represent nonviolent protesters in our community. Let me be clear, the protest community is not a monolith, nor should it be. However, we do share the same expectation to have our First Amendment rights upheld. Since June, the Trump administration has subjected people in Portland to chemical munitions and violence because of our words. While it can feel daunting to speak out in the face of threats, other nonviolent movements have shown us that this is what keeps us safer in the long run and what best protects our rights. Silence is not a winning path. This week, the Trump administration had to hear our grievances. I hope the judge will halt their barbaric treatment of our communities. And I hope Portland will continue to show up and use our voices. I joined this case so people in our city could regain some feeling of safety expressing their First Amendment. I ask you all to make good use of these protections. There is a growing sense of people power in this moment, of unity. Not unity in the sense of performative bipartisanship, but true, grassroots, working class solidarity. In that vein, I want to briefly speak to the agents who have been assigned to the McAdam facility, either in the past, currently, or in the future. This injunction would be a win for you too. I have heard you coughing and retching from the effects of your own chemical munitions. I imagine you have many of the same fears I do about the long-term effects of this repeated exposure. Please understand, this administration does not care about you any more than they care about me. I urge you to re-examine your role in suppressing the voice of the people to protect the whims of the powerful. I want to thank the people behind me for the incredible work that they have done on this case. I want to thank Judge Simon for understanding the importance of these matters. And finally, I want to thank everyone in Portland and across this country who are standing up to tyranny, however it is manifesting in this moment. Thank you.
And I think now, if you have questions, we'll take them.
So we didn't get that ruling today. Reaction to not getting a ruling and where you believe things stand right now.
Yeah, we're confident in the case that we put on today, and we look forward to the judge's decision. He indicated in court today that he expects to make that decision by Monday, so we'll see what he does.
Not all of Portland can be present at these hearings, and I think if they could, what might stand out is some of the decisions that were played related to training and policies. Can you maybe just highlight a few of your arguments related to things such as that you think might surprise the average?
I think the most surprising part of the training is that there was particular training provided to federal personnel who came to Portland specifically for Operation Skipjack. They were coming here for crowd control purposes, but that training focused on the use of force. In fact, the slides for that training did not show anything about First Amendment protections or protecting individuals who were not themselves engaged in nonviolent behavior. Rather, it was focused on how to use chemical munitions and other types of use of force.
Were you expecting to get a ruling today? You mentioned that he had indicated, or made some indications we heard about which way he was leaning. Were you expecting to get that final ruling today?
We're absolutely hoping to get a ruling as soon as possible. The TRO has expired, The judge did give a strong admonition to the government that it would be a really bad idea to violate the terms of the order in spirit, even if the sort of potential for sanctions doesn't hang over their heads currently. While it would have been nice to have an order today, we are still confident in the case that we put on, and we look forward to the judge's ruling as soon as he's able to make it.
Forward looking, should he rule in the injunction, what happens if an agent deploys tear gas at a protest?
I think this is when I say we'll see them in court.
Do you anticipate this case going to the injunction?
I can't quite hear you.
Do you anticipate the case, that's how the injunction pans out? I mean, is this the kind of thing that would go to trial? Or do you, like a,
Yeah, there's a lot of case left here, and so yeah, we'll see how the case unfolds. But we do expect that we'll continue zealously pursuing permanent relief.
you raised a lot of questions in the trial, and so I guess I'm just wondering if there are other questions you still have that you'd like to see resolved.
Well, one of the things that came out, particularly at the end, was the limited amount of officers that we got to speak to. So there's certainly more people that we want to speak to higher in the government. Additionally, if you look at the First Amendment complaint that we filed, there are many other claims that weren't even a part of this particular motion. So we will be exploring this.
And I ever that details the motion for injunction and something else was not released. I just clarify what exactly was.
Yeah, so we have filed both a motion for preliminary injunction and a motion for class certification. So the judge is going to make a decision on both of those things, whether he will recognize or certify a class at this point, and whether he will grant relief to that class.
I have just a broad question, but I'm wondering if you can respond to broader claims made by the DOJ in their closing arguments today. I mean, primarily, it seems like the foundation of an argument is we just need access to these tools, they say, because they claim they can't de-escalate if they don't have access to them. Is there any response?
I think the most obvious response to that is in the last 28 days when the temporary restraining order has been in place, their own officers have not raised a concern about the ability to access them.
Yes.